The CNN studio went silent. Judge Andrew H. Stones, his silver hair neatly styled, and his navy suit perfectly tailored, leaned forward, locking his sharp gaze on Caroline Levit. The 27-year-old former White House communications aide had just spent 3 minutes confidently arguing why the Supreme Court should overturn decades of precedent in the upcoming Davis v. United States case. Miss Levit, Judge Stones began, his deep voice carrying the weight of 30 years on the federal bench. I've listened carefully to your constitutional argument, and I'm reminded of something my grandfather once said. The camera captured Levit's expression, still composed, but showing the first trace of doubt as the veteran judge paused. He told me there's a difference between reading the Constitution and understanding it. What you've just presented proves his point exactly. The effect was immediate. Levit's confident expression stiffened. The show's moderator took a sharp breath. Within moments, that single line delivered calmly, without anger, but with the certainty of someone who had spent decades interpreting the Constitution, was spreading across social media and legal circles. The next 5 minutes wouldn't just shape the national discussion on constitutional interpretation. It would show what happens when youthful certainty meets decades of judicial experience on live television. Before we continue this remarkable exchange, please like this video and subscribe to our channel for more honest moments the mainstream media won't highlight. To understand why this televised debate mattered, we need to know who these two figures are and why their clash represents more than just a media soundbite. Judge Andrew Harrison Stones built his reputation over 3 decades on the federal bench. Appointed by President George H.W. Bush in 1991. Before becoming a judge, he taught constitutional law at the University of Chicago and published 3 influential books on judicial restraint and originalism. Known for his calm temperament and carefully reasoned opinions, Stones earned rare, bipartisan respect. After retiring in 2019, he occasionally appeared as a legal analyst, keeping the same even-handed approach that defined his career. I don't care which party benefits from the correct legal interpretation, Stones said in a Harvard Law School lecture after his retirement. The Constitution wasn't written to serve partisan interests, it was written to protect liberty through the separation of powers. Caroline Levit's rise was very different. Born in 1997, she graduated from St. Anselm College in New Hampshire and quickly climbed Republican political ranks. At just 23, she became an assistant press secretary in President Trump's White House, one of the youngest to hold that role. After Trump left office, Levit ran unsuccessfully for Congress in New Hampshire's 1st District, but established herself as a strong conservative voice. Her polished speaking skills and camera-ready presence made her a frequent guest on cable news, where she often argued that judges have twisted the Constitution's meaning. Our founding document isn't complicated, she frequently said on television. The problem is activist judges changing its meaning to fit political agendas rather than sticking to the text. The CNN segment that brought Stones and Levit together centered on Davis v. United States, a case testing Fourth Amendment protections. In the digital era, the Supreme Court was considering whether police need a warrant to access certain cell phone location data, question the Constitution's framers could never have imagined. Levit had been pushing for a strict interpretation that favored law enforcement, arguing the Constitution's text provided no protection for digital data. Her stance aligned with conservative law enforcement priorities but broke from recent rulings. Expanding digital privacy rights. Producers of Constitutional Crossfire, CNN's Sunday legal analysis show, paired Levit with Stones, expecting an exchange between 2 generations with opposing views. What they didn't expect was how strongly those views would collide. Behind the scenes, both guests were briefed separately to keep the debate spontaneous. Host Rebecca Martinez began the segment with a direct question to Levit about how the court should handle digital privacy given the Constitution's silence on modern technology. Levit delivered her usual confident argument. The framers wrote a clear, limited document, she said, looking straight into the camera. When we create rights that aren't in the text, like special protections for cell phone data, we are not interpreting the Constitution, we're rewriting it. Martinez then turned to Judge Stones for his response, expecting a calm academic rebuttal. What happened next became one of the most discussed moments in recent legal television history. The studio lighting highlighted both guests. At the sleek glass desk, host Martinez leaned back slightly. Sensing a serious debate was coming. Miss Levit makes a strong case for a textual approach, she said. She argues digital privacy protections are judicial inventions. Judge Stones, how do you respond? Stones folded his hands, his face calm. At 72, he carried the quiet authority of someone who had weighed crucial legal issues for decades. First. I respect Miss Levit's passion for the Constitution, Stones began, his tone steady. The challenge of applying an 18th document to technologies its authors couldn't imagine is real. Levit smiled slightly, expecting polite disagreement. But what followed dismantled her argument piece by piece. However, Stones continued, I must disagree with the historical and legal foundation of her position. Limiting interpretation only to what the framers explicitly mentioned misunderstands the Constitution's purpose. He pulled out a worn pocket Constitution from his leather portfolio. A deliberate gesture, the Fourth Amendment protects people from unreasonable searches of their persons, houses, papers, and effects, he read. The framers didn't list every possible item. They wrote broad principles to protect privacy from government intrusion because they knew circumstances would change. Levit, determined to push back, leaned in. Judge Stones, the framers were precise when they wanted to be. They listed houses, papers, and effects, not digital data. If we add modern preferences to the text, we're rewriting it. Miss Levit, Stones replied patiently. Think about what papers and effects meant in their time. Those were the private containers of personal information, letters, records, private thoughts. That's exactly what our phones store today. He flipped to another marked page. When the Supreme Court ruled in Carpenter v. United States that cell phone data deserves Fourth Amendment protection, it wasn't creating a new right, it was applying an existing principle to new circumstances, as courts have always done. Left quickly countered with familiar talking points. But Judge, that's the kind of living constitutionalism conservatives have fought for decades. Either the Constitution has a fixed meaning, or judges get to update it with current views. We can't have both. Stones nodded as Levit spoke, acknowledging her point with the courtesy expected of a seasoned judge before responding. That presents a false choice. Miss Levit, he said evenly, originalism doesn't mean ignoring technological or social change, it means applying the Constitution's original principles to modern circumstances. For example, the First Amendment protects speech, so that protection naturally extends to internet communication, even though the framers never envisioned websites or social media. He continued with the same deliberate reasoning that defined his judicial opinions. Justice Scalia, who was certainly not a living constitutionalist, recognized this in Kilo v. United States. Writing for the majority, he ruled that thermal imaging of a home required a warrant, even though the technology didn't exist when the Fourth Amendment was written. Levit, drawing on her media training, shifted the conversation. The bigger issue here is judicial restraint, Judge Stones. Unelected judges shouldn't be creating new rights. If people want additional privacy protections for digital data, Congress should pass laws, not courts invent constitutional protections. It was the opening Stones had been waiting for. His expression remained neutral, but those familiar with his style noticed the slight narrowing of his eyes, a sign that a key point was coming. Miss Levit, Stones said, his calm voice carrying unmistakable authority. Your argument reflects a basic misunderstanding. The Bill of Rights was created to protect fundamental liberties from majority rule. When the court rules that cell phone data deserves Fourth Amendment protection, it isn't creating a new right. It's preserving existing rights against government intrusion. As technology evolves, he closed his portfolio deliberately before continuing. James Madison addressed this directly when introducing the Bill of Rights to Congress. He said these amendments were meant to limit government power and serve as safeguards between citizens and the state. The studio had grown silent. Even the production crew stood still, aware they were witnessing an unusual moment of legal clarity on live television. The Constitution, Stones continued, was drafted with broad principles precisely because the framers understood that future generations would face new circumstances. As Chief Justice John Marshall wrote in McCulloch v. Maryland, "It is a constitution we are expounding, meaning its principles must endure as applications change." Levit tried to interject, but Stones raised his hand, slightly a familiar courtroom gesture that had silenced countless lawyers. She instinctively stopped speaking. Miss Levit, Stones said, his voice measured but firm. "I've listened carefully to your argument, and it reminds me of something my grandfather told me. There's a profound difference between reading the Constitution and understanding it, and what you've presented illustrates exactly what he meant." The words landed with quiet force. Levit's expression froze as she processed the implication. For the first time in her media career, she looked genuinely caught off guard. Host Rebecca Martinez sensed the weight of the moment and stayed silent, allowing the statement to linger. "Are you suggesting I don't understand the Constitution, Judge Stones?" Levit finally asked, her voice showing the first hint of irritation. Stones remained calm. "I'm suggesting that constitutional interpretation requires more than confidently quoting the text. It requires historical context, legal reasoning, and an understanding of how principles apply over time. When you argue that the Fourth Amendment can't apply to digital information simply because the framers didn't mention it, you're misunderstanding how constitutional interpretation has worked throughout history, including under conservative justices." He then outlined 3 cases where conservative originalist justices extended constitutional protections to new technologies, quoting directly from opinions that contradicted Levit's argument. Viewers could see Levit recalculating her approach in real time. Her usual confident smile had been replaced with the focused look of someone trying to respond to arguments she hadn't anticipated. When she spoke again, her tone was noticeably more measured. "I appreciate your perspective, Judge Stones. I still believe we should be cautious about extending protections beyond the text. But I understand your point about applying principles to new circumstances." Stones seized the opportunity to conclude with a final thought. "Constitutional interpretation isn't about being cautious or aggressive, Miss Levit. It's about staying true to the document's principles. The framers wrote a constitution of enduring principles because they knew they couldn't predict every future development. Our responsibility is to apply those principles faithfully, not restrict them to 18th century circumstances." As the segment neared its end, Martinez asked both guests for closing remarks on how the Supreme Court might decide. Davis v. United States. "I think the court has an opportunity to return to the Constitution's original understanding," Levit said, her tone moderated compared to earlier. "While I respect Judge Stones's view, I still believe the court should exercise restraint when extending protections not explicitly mentioned in the text." When Martinez turned to Stones, he responded with the same clarity that had defined his entire argument. "The court must choose between focusing on literal form or constitutional substance," he said. "If they look only at the fact that the framers didn't mention digital data, they risk ignoring the Fourth Amendment's real purpose, protecting private information from unreasonable government intrusion. I believe the court will, as it has before, apply the Constitution's enduring principles to modern circumstances." As Martinez thanked both guests, the cameras captured the defining image of the segment. Judge Stones calmly placing his pocket Constitution back into his portfolio, while Levit sat unusually still, her usual confident smile absent. Asterisk, the impact of Stones's pointed remark about reading versus understanding reached far beyond CNN's Sunday audience. Within hours, the clip went viral across social media, with legal experts, commentators, and viewers sharing and debating the exchange. Asterisk, constitutional law professors were quick to react, praising the clarity of Stones's explanation. Harvard's Noah Feldman posted, "In 3 minutes, Judge Stones delivered a better lesson on originalism than most students get in a semester. His distinction between principles and applications should be required viewing." Asterisk, by evening, the clip had been viewed more than 7 million times, with the hashtag #ReadingVsUnderstanding trending nationwide. Asterisk, reactions came from across the political spectrum. Conservative legal scholar Jonathan Adler wrote in National Review, "While many conservatives may instinctively agree with Levit, Stones offered a more historically accurate originalist argument. As Justice Scalia often said, originalism applies principles to new circumstances, not just old technologies." Asterisk, progressive commentators, usually skeptical of originalist reasoning, also praised Stones. MSNBC legal analyst Joyce Vance noted, "Judge Stones showed that principled conservative interpretation doesn't require limiting constitutional protections in the digital age." His explanation of how the Fourth Amendment applies to modern technology was both honest and practical. Asterisk, for CNN, the exchange was a rare ratings win. Clips were replayed across competing networks, and the conversation was widely cited as an example of thoughtful, substantive debate in an era dominated by partisan soundbites. Asterisk, asterisk. The White House, where Levit once served, remained silent about the exchange. However, former Justice Department officials from both Republican and Democratic administrations praised Stones's reasoning. Former Attorney General Michael Mukasey called it a masterclass in constitutional interpretation that rises above partisan divides. Asterisk, for Caroline Levit, the aftermath brought both challenges and opportunities. Publicly, she responded professionally. Posting on social media, asterisk, appreciated the opportunity to discuss constitutional interpretation with Judge Stones on CNN this morning. These important debates help our national understanding, even when we disagree. Asterisk, this measured response earned her praise from some commentators who had expected a defensive reaction. Political consultant Frank Luntz remarked, "Levit's dignified handling of a difficult media moment shows professionalism. She didn't attack Stones or play the victim. She treated it as a serious disagreement between serious people." Asterisk, privately, however, Levit was reflecting deeply. A close associate told Politico, Caroline viewed this as a learning experience. She respects Judge Stones, and having him directly challenge her understanding of constitutional principles made an impression. She's been reading some of his judicial opinions and writings to better grasp his perspective. Asterisk, this reassessment became public 3 days later, during a conservative radio interview. Rather than repeating her earlier arguments, Levit offered a more thoughtful view. Asterisk, after reflecting on my discussion with Judge Stones, I see there's a distinction between the specific technologies the framers knew and the principles they set. While I still believe in judicial restraint, I better understand how constitutional principles can apply to new circumstances without abandoning originalism. Asterisk, for Judge Stones, the exchange brought renewed attention to his judicial philosophy. Law schools reported increased interest in his books on constitutional interpretation, and the University of Chicago Law School announced a special symposium titled Principles and Applications, Constitutional Interpretation in the Digital Age. Inspired directly by the CNN debate, asterisk, speaking invitations poured in, but Stones accepted only a few, staying true to his reserved nature. At a Harvard law event, when asked about the viral moment, he downplayed it. Asterisk, what matters isn't any single TV appearance but whether we advance thoughtful understanding of our Constitution. Ms. Levit and I had a substantive disagreement. Exactly. The kind of debate needed to refine our understanding of fundamental principles. This gracious response further strengthened his reputation for prioritizing constitutional clarity over political wins. Yale law professor Reva Siegel observed, "Judge Stones isn't interested in scoring partisan points. He's committed to constitutional fidelity." The fact his explanation resonated so widely shows a public appetite for real analysis over political soundbites. The biggest sign of the exchange's influence came 2 weeks later, when the Supreme Court heard oral arguments in Davis v. United States. Justice Neil Gorsuch, a known textualist, asked the government's lawyer, "The Fourth Amendment's protection of papers and effects was clearly meant to shield private information from government intrusion. Why wouldn't that principle extend to digital data containing the same personal details?" Legal analysts immediately noted the similarity to Stones's CNN argument. Scotus blog wrote, "Justice Gorsuch's questioning reflects the same distinction between principles and technology that Judge Stones articulated." When the court ruled 4 months later, its 7-2 decision largely adopted Stones's reasoning, holding that cell phone location data is protected under the Fourth Amendment. Despite not being explicitly mentioned in the text, Chief Justice Roberts' majority opinion, joined by justices appointed by presidents from both parties, stressed that the Fourth Amendment's protection of papers and effects safeguards private information from unwarranted government intrusion. Regardless of the medium, constitutional scholar Oren Kerr commented, "The Davis opinion reads like an expanded version of Judge Stones's 3-minute explanation on CNN. His distinction between principles and applications has effectively shaped how the court now handles Fourth Amendment issues in the digital age." The long-term impact of the Stones-Levit exchange went far beyond the immediate media buzz. It influenced legal education, shaped public discussions on constitutional interpretation, and altered both participants' careers in ways neither expected when they sat across from each other that Sunday morning. 6 months later, Harvard Law School hosted a special symposium on constitutional interpretation, inviting both Stones and Levit. What could have been a tense reunion became an example of respectful dialogue across generational and ideological lines. Levit, now more studied in constitutional history, presented a refined perspective. "My understanding has evolved," she said. "While I still believe in judicial restraint and textual fidelity, I now better appreciate how constitutional principles must adapt to technological change without losing their core meaning." My discussion with Judge Stones was challenging, but it pushed me to think more deeply about originalism and its proper role. This intellectual growth won her praise from legal scholars, who had previously dismissed her as merely repeating talking points. Harvard's Lawrence Tribe, a leading progressive voice, said, "Levit showed something rare in today's public debate: the willingness to reconsider a position when faced with substantive criticism. That's essential for serious constitutional reasoning, regardless of ideology." For Judge Stones, the symposium offered a chance to underline a lifelong belief. "None of us has a perfect understanding of the Constitution," he said in his keynote address. "What matters is our commitment to studying its text, history, and principles and to refining our views when challenged by thoughtful criticism." The educational influence of their exchange spread far beyond Harvard. Law schools across the country began using the CNN clip in constitutional law courses to illustrate the debate between strict textualism and principled application. Georgetown law professor Randy Barnett, a prominent originalist, even designed a seminar around it, titled Text, Principle, and Application in Constitutional Interpretation. The Stones-Levit exchange is an ideal teaching tool, Barnett wrote in a legal education journal. It shows, in clear terms, the central challenge of constitutional interpretation: staying true to original meaning while applying it to circumstances the framers couldn't have imagined. Both textualist and living constitutionalist students found points of entry into the debate sparked by their exchange. Beyond law schools, public interest in constitutional principles surged. Sales of pocket constitutions rose noticeably in the months after the viral clip, with the National Constitution Center reporting a 30% increase in orders for its annotated edition. Asterisk, the center's president, Jeffrey Rosen, credited the Stones-Levitt exchange. Asterisk, they showed that constitutional interpretation isn't just for lawyers and judges. It's a conversation every citizen can join, ideally, with the same commitment to principle over partisanship that Judge Stones displayed. Asterisk, for Caroline Levit, the experience ultimately benefited her career in ways she hadn't expected. Her willingness to reassess her position publicly demonstrated intellectual seriousness, opening new opportunities. Harvard's Kennedy School of Government invited her to serve as a visiting fellow on constitutional governance, and several major publications requested opinion pieces on legal issues. Asterisk, in The Atlantic, 1 year after the CNN debate, Levit reflected asterisk, that exchange with Judge Stones could have been just another partisan TV moment, but it became something far more valuable, a catalyst for deeper understanding. I realized that defending constitutional principles requires moving beyond talking points and genuinely engaging with the Constitution's history and purpose. Asterisk, her evolution from political commentator to serious constitutional thinker culminated in her acceptance to Yale Law School, where she focused on constitutional law while continuing her public commentary. Asterisk, in her Yale application essay, published with her permission in a Yale alumni journal, Levit wrote, asterisk, being publicly challenged by Judge Stones helped me see that my passion for the Constitution needed to be matched by a deeper understanding of its interpretive history and principles. This wasn't about abandoning my conservative values, but about making sure those values are expressed through honest constitutional analysis. Asterisk, for Judge Stones, the impact was equally significant, shaping his educational legacy. His third book on constitutional interpretation, which had previously circulated mainly in academic circles, was republished by Simon & Schuster under the new title Reading versus Understanding: Constitutional Principles in the Modern Age. It became an unexpected bestseller, reaching readers well beyond the legal community. Asterisk, at 72. Stones suddenly had a broader platform to promote constitutional understanding, a mission he had pursued throughout his career. The University of Chicago established the Stone Center for Constitutional Studies, dedicated to public education on constitutional principles across ideological lines. Accepting its honorary chairmanship, Stones emphasized its nonpartisan mission. Asterisk, our goal isn't to push any single interpretation, but to encourage thoughtful engagement with our founding document based on text, history, and principle, not political outcomes. Asterisk, perhaps the most lasting impact of the exchange was how it influenced public discourse. Media outlets noticed that audiences responded positively to substantive constitutional discussions. Sales of legal books and increased interest in Supreme Court coverage suggested a growing appetite for serious legal analysis. CNN's Constitutional Crossfire, originally intended as a limited series, became a regular feature with consistently strong ratings. Asterisk, media analyst Margaret Sullivan observed, asterisk, the Stones-Levitt exchange proved that constitutional analysis doesn't need to be simplified for public consumption. When experts engage seriously with principles rather than partisan talking points, audiences respond with real interest. That's a valuable lesson for media, often tempted to reduce complex debates to political sound. Asterisk 5, years after their viral debate, Judge Stones and Caroline Levit appeared together again, this time as co-authors of an article in the Harvard Law Review titled Principle and Application: Finding Common Ground in Constitutional Interpretation. Asterisk, while acknowledging continued disagreements on specific cases, they outlined shared views on how constitutional principles should be understood and applied. Their conclusion reflected how far they had come. Asterisk, constitutional interpretation requires both fidelity to the text and recognition of how its principles apply to circumstances the framers could not have anticipated. When we move beyond partisan positions and engage seriously with the Constitution's history and purpose, we find more common ground than political divisions suggest. The Constitution belongs to all Americans, and understanding it demands continuous learning and intellectual honesty from citizens across the political spectrum. Legal commentator Jeffrey Toobin summarized the significance. What began as a viral confrontation evolved into something far more important, a model for how constitutional debate can bridge generational and philosophical divides. Stones and Levit showed that the most productive constitutional conversations don't end with winners and losers, but with deeper public understanding of our founding document. In moving from confrontation to collaboration, the Stones-Levit exchange ultimately embodied the very constitutional principle they had debated. America's founding document was never meant to be static. It is a framework of enduring principles, finding new meaning through thoughtful interpretation and good faith dialogue across generations.